Good afternoon, and thanks for joining us for today's webinar, Cybersecurity and Employee Benefit Plan Best Practices. I'm Danielle Ginter, Principal and Director of ERISA Services. With me today are, Dave, would you like to introduce yourself?
I would. Thank you, Danielle. My name is Dave Hanerberg. I'm a partner at the firm. I lead our SOC and cybersecurity practices. I've been with the firm a little over 23 years. In a prior life, I did 3 years with a third-party benefit administrator. So when I started here 23 years ago, interesting fact, I did a lot of employee benefit audits. But I have switched a little bit on the careers, and I'm excited to bring to you today some best practices.
Great, thanks, Dave. Zach, would you like to introduce yourself?
Yep, my name's Zach Starner. I'm an audit manager with McKonly Asbury. I've been with the firm for 9 years now, specializing in benefit plans, basically making up for Dave's slack.
That's true. It's true.
Hey, thanks, Zach. And we have a special guest speaker today. Renee, would you like to introduce yourself?
Sure. My name is Renee Lear. I'm an attorney with McNeese Wallace in New York. I'm chair of the Employee Benefits and Executive Comp Group, and so I practice in the both the welfare and pension area as well as non-qualified plans and executive comp. And I'm not going to tell you how long I've been practicing because that will age me.
Thanks, Renee. Okay, for those of you who don't know, McKonly Asbury is an accounting and business advisory services firm with offices in Camp Hill, Lancaster, and Bloomsburg, Pennsylvania. We provide a range of services to organizations across a variety of industries, as you can see on the screen, and we encourage you to visit our website to learn more. If you've joined us on past webinars, welcome back. If you haven't, our monthly webinars feature various business topics to keep you updated on what's going on around us. Be sure to check out our website to catch past presentations as well as current information through our blog. Questions, just please submit them through the built-in questions function in the webinar control panel. We'll try to get to them during the webinar. If we don't, we'll make sure that we answer them afterwards. Need CPE? Just make sure you answer all 3 polling questions during today's webinar. CPE certificates will then be mailed within 2 weeks after the presentation. So what are we going to talk about today? I'm going to go through a very brief accounting and oversight update. Renee's going to do a legal update from McNeese. Dave is going to talk about cybersecurity risks and how to mitigate. We'll talk about how cybersecurity is a huge focus of the Department of Labor right now. And then Zach will talk about lessons learned from recent ERISA court cases. So SAS 136, you've probably been hearing us talk about this for quite a bit now. It was in effect for the calendar year end 12/31/21 audits. Some big changes with SAS 136 related to the term limited scope going away. Those audits are now called ERISA Section 103A3C audits. Also with the report change, the report used to be 1.25 pages. It's now 4 pages long, and there's a real focus between what's management's responsibility versus what the auditor's responsibility is, and you'll see that'll be kind of a theme on the next couple of slides. There were also new acknowledgments in the engagement letter that were also mirrored in the representation letter. Again, a lot of these acknowledgments are around management's responsibility, like management's responsibility for having a complete plan document, management's responsibility for determining an ERISA Section 103A3C audit is permitted. And then lastly, reportable findings. And I think this is probably one of the biggest changes. So before SAS 136, if we found an issue like a deficiency that we didn't consider to be a significant deficiency or material weakness, or maybe a minor non-compliance issue, we could communicate those directly to plan management verbally. Now, after SAS 136, all of those items are now required to be communicated to those charging with governance in writing. So the threshold for what we have to report in writing is so small. Likely, if you're a plan sponsor, at some point you're going to have a reportable finding. And that might not excite you, but the thing to remember is it's so much better for your auditor to find it than the Department of Labor or IRS. We're not going to find you. We're just going to help you figure out how to fix it. Okay. Next slide. Thank you. Okay, first polling question. Have you received correspondence from the DOL or the IRS regarding your benefit plan in the last 3 years? Yes, no, or I'm not sure. I'll be curious to see what we have here because there is, as you'll see in the next couple of slides, a huge focus from the DOL or IRS on investigations. Renee, I don't know if you're seeing anything.
Right, so we are seeing an uptick. There was like the normal practice, and then COVID hit and things kind of slowed down, but it's definitely picking up again. And it's a lot of new individuals who have been hired by the IRS who are doing audits. So the audits are becoming more interesting with that.
Okay. We'll just give this another couple of seconds. Yeah, and the interesting thing about the Department of Labor and the IRS, as far as their enforcement, is now I feel like they're doing a lot more targeted. So you might not have a full audit, you might just receive a letter with them wanting to look at something very specific related to the plan. Okay, so 11% yes, 63% no, and 26% I don't know. Okay. So we're going to talk about a little bit about where the IRS is focused. So the IRS has this new program. It started in 2022. It's the IRS 90-day pre-examination compliance pilot program. So in the past, the IRS would have sent you a letter and you would have gotten an audit. There really wouldn't have been a whole lot in between. Now what they're doing is they're sending you a letter and they're giving you 90 days notice. So during this 90 days, their hope is as a plan sponsor, you're going to go through your plan document, you're going to go through it with a fine-tooth comb, and if you find any issues, don't panic. What you can do is if it's something that you can self-correct, you can go ahead and self-correct, then send it to the IRS for the review. And at that point, they'll either say, yes, we're good with it, they'll send you a closing letter, or maybe they'll decide to do a limited audit, or maybe they'll decide to do a full audit, but it's better for you to be upfront with it as opposed to them just finding it. So say you have an error and it can't be self-corrected. That's okay too. You can let the IRS know what you found. They ask for a closing agreement. And so at that point, usually a closing agreement, the fees are pretty significant. They will cap the closing agreement fees to those in the voluntary correction program. So those fees range from $1,500 to $3,500, which may still seem like a lot, but that's significantly less than a typical closing agreement. And so just the goal with this is just to reduce taxpayer burden and also the time the IRS is spending on these plan examinations. All right, so the Department of Labor is also very, very busy as it relates to enforcement activities. They're doing another audit quality study, and this is where they select a sample of audits to review to assess the quality of the audit. And so the last time they did this, they released it in 2015, and SAS 136 that I talked about earlier was a direct result of this. So the interesting thing about the audit quality study is they won't just inform the auditor that they're being audited, they will inform the plan sponsor because again, they feel like the plan sponsor is responsible for everything as it relates to the plan, even the audit. The second thing that they're doing is they're looking for missing audit reports. So say you file your 5500 and for whatever reason your audit isn't ready, maybe you'll put a letter that says, oh, we're working on it. DOL does not like this. So they'll send you a notice of rejection and you'll have 45 days to fix it. So then say you don't respond to the notice of rejection or say you don't file your 5500 at all, then you'll get a notice of intent to assess the penalty and you'll have 35 days to respond to it. And at that point, like that's your last chance. The DOL also has two priorities they're working on, 7 national projects. For time's sake, I'm not going to go through all of them, but if you're interested in them, please let me know afterwards and I'll send you more information. The 2 that I wanted to point out though, one is related to ESOPs, especially around the proper valuation of employer stock. And the second one, which you've probably heard us talk about before, is participant contributions and making sure that they're getting remitted timely to the plan, or even just getting remitted at all. Zach will have a couple cases later that he'll talk about related to this. And then lastly, your typical DOL investigations. So again, this can come from a variety of reasons. It could be participant complaints. DOL can see something in the news related to the plan sponsor. It could be because of one of their national projects. Maybe the IRS looked at your plan and then they want the DOL to do another review of it as well. Or it could just be an error on your 5500 that stood out to them. The key to whether or not the IRS or the Department of Labor elects to audit your plan or look at your plan, just make sure you're responding and you're responding timely and you're letting all of your service providers in the loop on it so that they can help. Okay, then I'm turning it over to Renee.
Thank you. So I just want to talk about a couple of things that have popped up on the legal side for the legal update. And one has to do with cryptocurrencies. And earlier in this year, Fidelity came out, and Fidelity, as you know, is like a national provider for 401k plans. They came out and said, hey, look, use Fidelity for your 401k, and you can invest in crypto. The DOL immediately came out and said, whoa, 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 let's wait a second here. We don't like this. And we don't like it because, crypto is speculative and it's volatile and there's valuation concerns. Next slide. So what the DOL did was the DOL, issued this release and reminded employers and plan fiduciaries that there is a fiduciary duty in determining which assets you're going to offer under your plan. Well, immediately after the DOL did this guidance, they were sued. And they were sued by a company called For Us All. And what For Us All did was that was their marketing plan. It was an internet company that said, hey, how's your 401k here, and we'll let you trade in crypto. They sued the DOL and they said that, okay, you didn't follow the procedures in actually issuing this release. The DOL came back in filings in the court case and said, oh, no. So the release that we published, it's not law. We're just reminding employers that they have a fiduciary duty. And we're just letting them know that if they trade crypto in their 401k, that we're going to have an investigative program and we're going to investigate their 401ks. But it's not stopping anyone from doing it. We're just letting them know. Essentially what they're saying is they're letting everyone know that you're going to be a target. And with that, that's actually very timely with the FTX collapse. FTX allowed that you could have a solo 401k on the FTX exchange. So if you had your 401k there, you essentially have nothing now because of the collapse. Next slide, please. So in following up with that, let's talk about the other big topic this year, and that is fraud with 401ks and retirement plans. And before we go into real depth with that, let's just think about how fraud presented itself in the past. And, in the past, it was always someone that you knew who committed fraud against you because that was the easiest person that had access to your information. Take, for example, this plan. This happened in 2004. It was a married couple. The husband leaves the wife, they get divorced. He moves somewhere else in town, and never changes his address with his employer. So the employer, they're going to go, let's do web-based retirement planning. So they send a letter to the address they had on file, and the address said to be opened by the addressee only. Okay, so let's be honest. It went to the ex-wife's house. The ex-wife got the letter. Do you think the ex-wife cared that it said to be opened by the addressee only? No, she did not. So when she opened the letter, she saw that all she needed to know was essentially his Social Security number. And she was able to create an online account that accessed his retirement funds. And so what do you think the ex-wife did? Next slide, please. She spent $42,000 is what she did. She was able to withdraw his entire account balance. Now, the same year, later in the year after she wiped it out, he called to update his address, which is, approximately 18 months after he had actually moved. And no one said, well, your account balance is zero. But what they did do is they sent him the 1099 at the beginning of the next year for him to pay taxes on it, and this is where he found out. He sued, but the 10th Circuit said that the plan didn't do anything wrong. He did, because he didn't follow the plan procedures by updating his address. And the fact that they sent the information to the ex-wife, that was actually his fault. Next slide, please. So not to pick on ex-husbands, let's talk about an ex-wife. I'm sorry, not to pick on ex-wife, let's talk about the ex-husband in this case. So in this case, and it wasn't even an ex-husband, it was an estranged husband. The wife lived in one area of the country, and the husband had left, and he was living somewhere in Florida. And he had somebody call the company and change the address for the account. Now, meanwhile, she filed a claim for benefits, and for early retirement, and they were processing the paperwork. But they mailed the check to him. Next slide, please. And of course, he cashed it and he spent the money. But in this case, the plan had a procedure that you actually had to change the address in writing. And what the husband did was have a female call and change it over the phone. So in this case, the company didn't follow their own procedures. So the court said the company actually needed to make the wife whole. Next slide. So let's fast forward it a little bit. And in this case, so Leventhal was an attorney in the Eastern District of Pennsylvania, so that's outside of Philly, or in Philly, in that area. And this occurred pre-COVID, when working remotely was not as common as it is now. And this attorney allowed one of his employees to work from Florida, but the way that he had his system set up, her connection to their server was not a secure connection, and she was hacked through a personal email, and so his server was hacked. And when hackers hit at law firms, they kind of they look around and they were like, it's a law firm, there's really not much here, so let's just sit and wait. So they sat and wait. So Leventhal decides, well, you know what? I'm going to take a partial withdrawal from my retirement plan. And he filled out the paperwork and he scanned it into his work email and he sent it off. And he received a partial distribution. Meanwhile, the criminals said, this is awesome. We have all of his information. And so what they did was they copied the email, they took the form, and they actually cut and paste on the form that he had submitted, like changing dates, changing amounts. But when you looked at the form, you could actually tell that it looks like it was manipulated. Next slide, please. So Leventhal sued, the administrator and the custodian, and said, you can look at the form and tell it was manipulated. And the court said you're right, that's a good suit. We're going to let you go forward with this. But then they turned around and countersued the law firm, saying that because it was not a secure system and it was able to be hacked, that the law firm should also be responsible for the loss that this attorney experienced. And the Eastern District Court said, you know what, that's a good argument. I want to hear more about that. Now, when you connect the dots, the law firm has the same name as the attorney who was hacked. So what, it would be like he's indemnifying himself, or he's indemnifying the people that he is suing. So in this case, they actually, they settled the case outside of court. But it was interesting because now the employer, technically his employer, his law firm, could be liable if it's their system that's hacked, and if that's what helps with the fraud. So next slide, please. So let's go to this year. Miss Disbury. Miss Disbury worked for Colgate, and she's lived in South Africa since 2008. In 2020, she attempted to access her account, but it was blocked. what happened was, in September of 2020, she was notified that her $750,000 had been distributed. So what happened was, in early 2020, a fraudster picked up the phone, contacted the administrator, and requested to update the information on file. And it's amazing when you look at all these cases and you hear all of the things about fraud in retirement plans. These criminals actually pick up the phone and call. I mean, they hack you, but they also pick up the phone and call. So this individual picked up the phone and called, and wanted to change the information, and the plan said, well, we need to send you a PIN. So they mailed the PIN to the address that they had on file, which was in South Africa. Apparently, the PIN never got to the participant. Someone intercepted the PIN. Next slide, please. But apparently, this is common. So the fraudster, who was actually in Nevada, or actually had a bank account in Nevada, somehow got the PIN and used the PIN to update the participant's address, the participant's phone number, email, and bank account information. So she previously lived in South Africa, and the new bank account was in Las Vegas, Nevada. The fraudster tried to take a lump sum distribution, and when they couldn't, they actually called the retirement plan and said, hey, look, I'm trying to take a lump sum distribution. And the administrator said, well, you're supposed to wait 14 days before you can do this when there's a new address or a new bank account on the information, but let me help you out here. And the administrator processed the check to be mailed. Excuse me. So in this case, the plan didn't actually follow its own procedures when it mailed out a check for the $750,000. The same individual, because he or she had access to all of the participants' information, also tried to take a lump sum distribution from the defined benefit plan that she had at Colgate, but the defined benefit plan administrator required additional information. They were actually required a copy of the driver's license, and the fraudster didn't have that, so they weren't able to do it. So the reason why I said it's this year, because this year is the year that they actually sued. They sued in July of this year, and the individual requested that her benefits be restored because the plan didn't follow its own procedures. So the bottom line is, when it comes to fraud, the plan needs to follow its procedures, because even going back to when it was the estranged husband trying to take money from the estranged wife, the company lost because they didn't follow the procedures. In this case, again, even though it's a new case and it hasn't been decided yet, and there's some issues with her case because she didn't follow the administrative procedures that she's required to follow, I would predict that a judge down the line would say that she's entitled to be restored her $750,000 because the plan administrator didn't follow the procedures of the plan. So, next slide, please. So with all of that, because fraud is very prevalent right now, I mean, a lot of people had time on their hands when they sat home at COVID and they had computers. So the U.S. Government Accountability Office did a report on defined contribution plans, and and when you look at it, you see, I thought this was an awesome picture or depiction, because when you look at it, as an attorney and working with all of these providers, I know that the payroll providers have your name, date of birth, social security number, and that information, but when you look at it on this slide, it's like, wow, yes, your personal information is flying everywhere. And from the employer's perspective, this is your employee's personal information being, it's going everywhere. And like I said, fraud is very prevalent now. And this is when I am going to turn it over to Dave after the polling question.
Thank you, Renee.
So polling question number 2, do you have a formal documented cybersecurity program? Yes, no, not sure. So when I spoke earlier about the national projects that the DOL are focused on, cybersecurity isn't part of the 7 national projects right now, but they said that's next on their list. So I anticipate seeing a lot of DOL when they do their investigations, a lot more questions as it surrounds cybersecurity. We'll just give this another couple seconds. The other thing I wanted to mention to you, Renee, is I did see the Department of Labor speak last May, and they talked quite a bit about cryptocurrency and how much it made them uncomfortable for participants' sake.
Right, and after what happened with FTX, I can definitely see the Department of Labor saying, "See, told you."
Right. Okay. Great. So do you have a formal documented cybersecurity program? 54% said yes, 22% said no, and 23% said not sure.
Thank you, Renee, for that lead-in. That was perfect to get us into best practices for cybersecurity. Bringing up the slide here. United States Department of Labor cybersecurity program best practices. It doesn't matter what industry you are in, everyone's coming up with cybersecurity best practices. If you looked at 12 different industries and you looked at all their best practices, 90% of them would match up. It's an issue for everyone, and it's a huge issue for you guys. As Renee's last slide said, the type of PII information you have and the amount of different participants is amazing. Plus, you have the opportunity then to commit fraud and steal the money as well. So, sell the information, commit fraud. It's like, Walmart for criminals. So it makes sense to have a best practice list. One of the things that Renee said was following procedures. We want to make sure that when we get into these best practices, that when we document, we follow. So just want to emphasize that. But you can go to the next slide. So the first one on the list is a formal, well-documented cybersecurity program. I believe it was 54% said they had one. So if that's true, I want those 54% to think of the next, there's 12 best practices. So the next 11 should be found in that cybersecurity program. A well-done documented cybersecurity program will carry and cover all of those best practices. So that best practices should be documented. A lot of times I'll do a SOC 2 audit. We do pre-assessments and we'll go in there, and people do a lot of great things, but they don't do documentation well. So as we're going through this, think, do you have it documented? Can you reproduce it? Is there evidence? And we will go to the next slide. Actually, can you go back to the other slide? I'm going a little too fast. So with a formal documented cybersecurity plan, there's 6 things that's going to do. It's going to identify the risks of the assets, information, and systems. It's going to protect each of the necessary assets, data, and systems. It's to detect and respond to. It's going to recover from an event, and it's to disclose the event as appropriate, and it's going to restore to normal operations. Again, I said the next 11 things is going to do those 6 things. So keep those in mind. A well-documented cybersecurity program should be approved by senior leadership. It's something that's going to develop as the organization develops, as risks develop, and that should be reviewed at least annually, if not more than that. I know with our SOC 2 practice, we look into that all the time. Are your policies reviewed annually? The other big thing is, do your users know about the policies? I've seen a lot of organizations with fantastic policies, and Danielle and Zach have no idea they exist. They're the employees of the organization. They have no idea they exist. And how are they to follow those if they have no idea? I mean, Zach may not follow them anyway, but Danielle's going to do a good job. So the other thing is the Department of Labor is saying the policy or the security program should be reviewed by an independent third-party auditor, which is a little different than other industries. They're actually coming out and saying, hey, a third party should review this. They're not saying what they should look like, but they're saying, hey, we're going to come out and review it. You should have these 12 things in there. And then use a particular framework. That framework could be NIST for cybersecurity. There's tons of frameworks out there. You could use the SOC 2. So we just have to make sure whatever framework you choose, you abide by it. If you're not using any framework at this time, I suggest NIST for cybersecurity. And we can move on to the second one. Prudent annual risk assessments. So I always ask, do you have a risk assessment? And I would say probably 4 out of 10 times a new SOC 2 client will say, yes, I do a pre-assessment, or I do a risk assessment, my apologies. And a risk assessment really is going to identify what your gaps are. So for those 60% of organizations that don't have a risk assessment, how do they think they effectively handle their risks? Those organizations most likely are putting too much money into mitigating certain risks and not enough money or resources into mitigating other risks. So when you do a risk assessment, you're mapping current controls as well as figuring out what gaps you need to fill in order for those risks to be mitigated. So it's really important, and that needs to be at least an annual process, and even more if there's changes. So it's a important thing to do, and it's probably one of the first steps in understanding where you are as an organization. Go on to the third one. A reliable annual third-party audit of security controls. This could be a pen test, vulnerability assessment, but we're looking for an independent auditor to assess the secure organization security controls. Do you see, Danielle and Zach, do you see a lot of your organizations getting third-party penetration tests, vulnerability studies, et cetera?
I think it depends on the size of the organization. If the larger the organization, they're tending to do this. If it's something an organization that's a little smaller, they might not have thought of this yet.
And how about you, Zach?
Yeah, I would agree with Danielle. You certainly see this more at larger organizations versus the smaller mom and pop shops.
Overall, everyone's going to have to do it. And that data, I don't think that the way criminals are today, they're going to attack everyone. It's so easy and so cheap to attack people. We're going to attack the small guys and the large guys. So it's important that they fall in line with these best practices. Go on to the next one.
I think it's important too, Dave, to make the point that, once there is an attack and once they get in, they're going to circle back around. It's not like it's a one-time thing.
Right, I agree. So clearly define and assign information security roles and responsibilities. This goes back to probably small and large organizations. The larger organizations are going to have a CISO, have someone who's in charge of security, but it doesn't matter how small you are, you're going to have a point person in regards to security. With that sufficient experience, necessary certifications, and if that small person can't do that, then they're going to have to bring a third party in to do it for them. It's important to know you can't do a risk assessment without a security officer or someone with that experience. You might call them something different. Like I said, the number one thing here was a formal, well-documented cybersecurity program. It's all connected. We can't do one of these well without doing another. So really important to have the right experience and knowledge. And as McKonly Asbury, we've helped clients go in, help create policies. So there are organizations out there that you can lean on. You don't have to hire, $180,000 CISO to get it done. But you need to get it done somehow. really what it comes down to. And that individual really needs to keep up with their education. It's just such a changing environment. And like I said, that risk assessment should be done at least annually, and it's going to change quite a bit. So go on to the next one. Strong access control procedures. Another comment about all 12 of these is, these are becoming more table stakes, more that everyone should be doing them. You'll note we found a lot of cyber insurance policies are not getting renewed this year because of certain aspects that are table stakes, multi-factor authentication, policies, stuff that we should be doing in 2022 that aren't being done. So strong access control procedures, that makes sure that, when Zach logs in, we know it's Zach and it's not Danielle. We want to make sure that, if Zach gives his username and password to someone else by accident, that they still can't get in because of that multi-factor authentication. If you're not using multi-factor authentication, you really need to get on that bandwagon. It needs to be at least on the external portion of your network, but I am seeing insurance companies that want it even internally. I know here at M&A we've been doing it for years, but again, it's table stakes, and we need to get better at that. Access privileges should be reviewed at least every 3 months. That means, who's going through and making sure Zach still works here? Does Zach still work here? Or was his last day last month and he's still, in the system? Do we have policies and procedures around activating an individual and terminating an individual? Are they being followed?
Hey, Dave, so you mentioned something interesting. So a lot of times when we get SOC reports from third-party service providers, if they have an exception, it's typically our terminated employees' access being deleted in a timely basis. And a lot of times they'll be like 10 out of 80 were not deleted on an. How concerned should like a plan sponsor be with an exception like that?
I would look at all the exceptions in the report as a group and then kind of decide if that was the only exception. And what was it? You said 8 out of 10?
Yeah, say 8 out of 10 or 1 out of 3. And a lot of times they'll say, like, the management's response will be like, we went back and we double checked that no one accessed it after the fact.
Right. Yeah, I would look at that, and like you said, management's going to have a response in the last part of that SOC 2, section 6 in ours, and they're going to respond to why that happened. It could be COVID, it could be, there was a transition in the IT department, but I would have to be fairly comfortable with that response in order to get comfortable. A SOC 2 just doesn't mean that's all they have. If you have more inquiry after looking at that SOC 2, ask the client, ask that service organization who owns that, who has that SOC 2. But I think you should look at it as a group. But everyone makes mistakes, but why were they made? And in that response, how did they fix it? And how going forward is it not going to happen? That's what I would be looking for.
Makes sense.
And I think with a lot of these things, it's like the PIN that was sent to the user's house. That's the second form of authentication. So we've got to be careful what form of multi-factor authentication we're using. And we have to take it upon ourselves. We have some responsibility as a user to protect our data. Changing our address, keeping that PIN to ourselves, making sure we have our phones locked, etc. So I always say, if someone tries hard enough, they're going to get your data. You want to be hardened more than the next guy, right? So you want to do as much as you can so that you are not the victim. Number 6, assets stored in a cloud managed by a third-party service provider are subject to appropriate security reviews. This really where it comes into, are you asking for a SOC 2 from your service organizations? If they don't have a SOC 2 And a service organization could be a data center, could be a managed services, it could be someone holding your data, someone providing a service for you. And that SOC 2 is going to verify a lot of different things, security, and depending on the principles that SOC 2 has, it could be security, availability, confidentiality, process integrity, or privacy. Every SOC 2 has security. In your situation, I think I would be looking for privacy and security. Those two are the biggest principles. If they just have security, that's great, but then I would ask, hey, what about privacy? So that would be a good move. If your organization doesn't have a SOC 2, it's not the end of the world, but then I would definitely have a checklist on the side that I go through with that organization and figure out if I can get comfortable with where they are. The beauty of a SOC 2 is it's audited by a third party, and you can rely on it. Zach and Danielle, any thoughts on SOC 2 for cloud providers?
I mean, I think they can provide a lot of information, and I think to remember not only to ask for it, but to read it and to go through like kind of what we mentioned, like the exceptions I typically see are related to the security as it relates to user access. But I've also gotten SOC reports where the report has been qualified too, and I would really encourage plan sponsors not to hesitate to ask the service provider, like, what are they doing about these types of things?
Right. Yeah. If it's a qualified plan, why is that? That means the criteria wasn't met, and that's usually a big deal. So figure out why. That usually doesn't happen if an organization is taking a SOC 2 fairly seriously.
Mm-hmm.
All right, we'll go on to the next one. This has been beat to death. Cybersecurity awareness training. Obviously, everyone knows we should be doing it. Should be doing it annually. We should be doing it monthly. But can you effectively say you're doing it? Can you produce evidence that Danielle and Zach both went to training? Are you phishing employees? What are you doing? That we should be re-looking at security awareness all the time. Because the criminals they're thinking of different ways to attack us. We should also be teaching our employees. Phishing isn't to trap employees, it's to educate them. One of the things we do is we have a lot of controls in place to protect the employee in regards to something getting to them. Sandboxing. So your emails, when they come to people, they get detonated before they get to the individual. So an attachment that Zach opens has already been detonated. A link that Danielle clicks on has already been clicked on. Is that foolproof? No. So we have to make sure that the last line of defense, which is our employees, which is our biggest risk, know what they're doing. And I think we have to emphasize or let employees know that's education. So when Danielle goes out there and she clicks on a link that we're testing, she will be automatically sent to training. She'll do a class, and it's not, I guess it is a little bit of a punishment, but it's a learning process, and that's why we're there. I'd much rather Danielle click on a link now than click on a real link and have ransomware or something else that affects everyone. So very important. And if you're not doing it now, you really need to get on the horse on that.
She gets a lot of trainings, doesn't she, Dave?
Well, I was going to say you more than that, but that's all I got to say on that. Number 8. So secure system development lifecycle program. This is probably the one item on here that, depending on your organization, a smaller organization isn't going to develop in-house applications. A smaller organization is probably going to have off-the-shelf applications. A SDLC program would say that, there's different phases, but a 7-phase SDLC program would be planning, analysis, design, development, testing, implementation, and maintenance. And I've seen a lot of different development life cycles through the SOC 2 process. You really have to document what's good for you and understand the sophistication you need. So I don't have a whole lot to say on that other than, if you're using off-the-shelf programs, do your reviews. When you're doing penetration testing, let your penetration tester know, hey, I would like internal penetration tests as well on applications. Something that could help you in the long run. But for those organizations that are creating their own applications, really need to have that documented and then a third party test that. Do you see a whole lot of in-house applications, Danielle?
No, not a whole lot. Especially as we were talking about, like the smaller organizations, they typically don't have that.
So out of all these 12, 8 was the one that stood out to me as, it's good practice, but it's not necessarily across the board. So, number 9. All right, business continuity, disaster recovery, and incident response. Again, all this is going to be covered into your program. Business continuity. How are you going to recover, resume, and maintain business functions? It's real important. If you don't have that documented and it's just in your head, it's not going to operate properly. You need to have it written down, documented, and you need people to know what their responsibilities are. That business, the business continuity, disaster recovery, and the incident response plan should have a team with them. They should meet at least annually to go over what their responsibilities are. Disaster recovery, recover, resume an organization's IT infrastructure, business applications, and data services in the event of a major disruption. It could be an earthquake, a fire. How are you going to recover? And then an incident response plan. That is pivotal to have, and it needs to be tested. Ransomware, what are you going to do? Law enforcement, marketing, human resources, what are we going to say to the public? I've seen a lot of good organizations that have good products have an incident, and there's 85 people telling different stories about the incident. Why? Because they weren't trained in the beginning to say, hey, we're going to put one story out, it's coming from this individual. They didn't have that message. So we really need to document an incident response plan, and when it happens, we have to follow it to the letter. Go on to the next one, number 10. Encryption and sensitive data stored in transit. We want to make sure that no data is sent over email that is confidential or sensitive. Email is just plain text. If I can intercept it, I can read it. So there should be nothing that goes over that. You should have at least a product on your system that is going to recognize whether it's a social security number, a credit card number, and block that information. Office 365 can do that for you. But again, anything that is sensitive needs to go on a portal, and it needs to be encrypted in transit. If you don't have the technology, then ask the person you're sending it to, hey, do you have a portal? Can I use to send it? The days of just sending stuff through email is over. Unfortunately, I see a lot of our clients still send stuff through normal email, and it's a training thing, and hopefully it goes down, but it's still a big issue.
I'm still seeing that as well, Dave.
How about you, Zach?
This is Renee. I'm seeing it as well, and most of the time I'm like, whoa, don't send that to me. delete.
And we do audits of email. 10% of our email, 10% of our users get audited a month here at McKonly Asbury to look at what's being sent. We have automated policies and procedures, but to look in, hey, should this really have been sent? And I think that mechanism needs to be in place. How do you make sure that things aren't being sent that shouldn't be sent? And I've seen a real reduction in the amount after those audits.
Yep. I think with sensitive data, Dave, that's one thing. We're doing a lot better than we were 2-3 years ago, but we can always get better.
Right. And number 11. Strong technical controls, implementing best security practices. We want updated hardware, updated software. We want this stuff patched. Are you segregating your guest network from your production environment, your guest wireless? Are you patching your systems? Is that an automatic process? Are you backing up your stuff? Are you testing your backups? All this stuff, regular antivirus software. If you're still using regular antivirus software, you're probably behind the times. You should be using an EDR application that's going to have more of a detection and response to it. An example of that would be Sentinel-1. Ransomware comes in, it detects it, and it locks it down to that one box, as opposed to, antivirus is better than nothing, but there's so much better out there. And I think cyber insurance is going to catch on to that. You're going to see more, hey, do you have an EDR application, as opposed to, do you have just antivirus? But I don't see that yet. And number 12, responsiveness to cybersecurity incidents or breaches. This really comes down to your incident response plan. If you don't have one, you're going to be slower off the line. And if you do have one, you're going to follow it. It's going to be quick. You're going to inform the right people. You're going to have a one message to the public, and at the end, it's going to help you recover quicker. So again, we want to respond to those incidents, but again, it all comes down to, do you have a policy? And we'll go to the next slide. I think we will hand this off to,
We have one last polling question. Who has fiduciary responsibility for a benefit plan? Plan sponsor, auditor, third-party administrator, all of the above. And thanks, Dave, for that. As it relates to cybersecurity, I think something that's important too is the tone at the top. I think if the top level individuals in an organization are saying how important cybersecurity is, then I think your employees are going to take it very seriously as well. I know I personally don't want to get in trouble with Dave, so I take it very seriously.
I agree, and I think, from a phishing standpoint, you cannot segregate your employees. In other words, your owners, the high-level board members, senior management, they all have to go through that security awareness training, because they are going to be the biggest targets and probably the least aware of the risks. So again, we need to, when we fish employees at McKonly Asbury, it doesn't matter if you're a partner, staff, you're going to be go through that training.
Okay. Plan sponsor, auditor, third-party administrator, all of the above. So really the Department of the Labor, unless you have an investment advisor that is taking that fiduciary role, really the ultimate responsibility is going to be that at the plan sponsor. And the reason why I say that is when the DOL or the IRS, if they were to come to take a look at your plan, that's who they're going to ultimately hold responsible if there's anything that they see questionable about it. Okay, and I think Zach is going to go through a couple of cases. We're a little short on time and want to make sure we wrap up at 3 for everybody, so we'll probably just go through 1 or 2 of these.
Well, we know Dave got a little long-winded with his section, but that was to be expected. So polling question number 3 is a great segue to our first case study here. The reason I picked this particular case study is because it specifically relates to our ESOP folks. So in this particular case, this involved Kurt Manufacturing, and they received a business valuation from Reliance Trust Company that severely overvalued the stock of the company. So when the ESOP purchased the company's stock, they actually essentially paid a premium and overpaid. So the takeaway here is Kurt Manufacturing, the board of directors and the fiduciaries failed to monitor Reliance's determination of the stock value. And I think that comes back to, as a plan fiduciary, you need to be reviewing the company valuation and understanding what goes into that, and how your third-party service provider is determining that value, because at the end of the day, as we see here, you're ultimately responsible for that valuation. Next slide, please. So here we can see that this mistake or breakdown of fiduciary responsibility ended up costing the companies millions of dollars. In total, $9.4 million was recovered for participants in the Kurt Manufacturing ESOP. So how that's broken down is Reliance Trust Company had to restore approximately $8.4 million to the plan. The board of directors and plan fiduciaries were responsible for another $984,000, which is comprised of a piece of the value of the company stock, but also over $215,000 of penalties for violating ERISA. So I think that really hits home that even though the board of directors and the plan fiduciaries didn't necessarily perform the evaluation over the business, they are ultimately responsible for assessing that it's reasonable and correct. And that clearly was not the case here in this particular case study. Danielle, Dave, anything else to add?
Yeah, you know, and like I said, that's why we kind of talked about that ultimate fiduciary responsibility. Even if it may not be something that you're an expert at the end of the day, it will typically fall on you to be able to substantiate it. And so just with ESOP valuations in and of itself, like a couple of things that you could think about doing is you could have an independent trustee who's going to review it for you each year. I've also seen where people have hired a second valuation to do like a peer review of the independent valuation that they're getting. So that's a couple of other options to think about just from an expertise standpoint.
Next slide, please. So here's another ESOP case. This situation is a little bit different in the fact that the company and company management actually misrepresented certain things in their financial statements that, when they were going through the valuation process, actually kind of inflated the value of the company, which in turn caused the ESOP to overpay for the stock of the business twice, once in 2006 and once in 2008. So again, because basically plan management, or not plan management, company management perpetuated this situation, the CEO himself was responsible for restoring over $540,000 to the plan. $351,000 of that, again, was for the overpriced stock, and then he was assessed approximately $190,000 in interest and penalties under ERISA. Next slide, please. Thank you. So this case is a little bit more straightforward. This is kind of the traditional 401k example, if you will. This was a company out of Baltimore, and the owner failed to forward employee pay deductions for contributions, as well as the company match and safe harbor contributions from 2017 and 2019. So what was the result of these either errors or withholding these deductions and not remitting them to the plan because they were used for something else? The owner was removed from their fiduciary position, and they're barred from permanently serving permanently from serving in a fiduciary capacity going forward, meaning they'll never be able to be a plan administrator or anything like that anywhere else. They were ordered to restore the missing contributions, as well as pay the cost of an independent fiduciary to now run and administer their plan, because they failed to do so. Danielle, any thoughts or comments?
No, I think just keeping in mind that it's 3 o'clock, I think this would probably be a good place to wrap up. But if anyone has any questions about any of these cases or the ones that we didn't get a chance to go over, please don't hesitate to reach out to us at the end, at any point, really. If you want to go over to the contact us slide, we can just wrap up. So thank you again for joining us for today's webinar. If you have any further questions, as I mentioned before, just please feel free to reach out to one of us and we'd be happy to assist. Once again, a special thanks to Renee for your insight into today's topic. A recording of today's presentation will be posted on our website and social media sites in a few days. And for those of you who have requested CPA and answered the polling questions, those certificates will be sent out within the next 2 weeks. Make sure to please save the date for our upcoming December webinar focused on ethical skills for leaders and the unexpected benefits for organizations and employees. We will also be starting 2023 with a webinar from our partner, Dale Carnegie Mid-Atlantic, focused on self-awareness, leading with emotional intelligence. Please make sure to check our website for more information about these upcoming events. Thank you again for joining us and enjoy the rest of your day.